recognizing the member from Surrey Panorama.
Yeah, I think I just have some simple questions. For the first one, can the minister explain why private post-secondary institutions are not required to implement a sexual violence policy under this legislation?
Recognizing the Minister of Post-Secondary Education and Future Skills.
Thank you for the question. So with this legislation, there's it specifically applies to public institutions because there's already different requirements for private institutions, and they have policies under different acts. So the Degree Authorization Act, the Private Training Act, and the Education Quality Assurance Policy apply to private institutions, and they have requirements there to have sexual violence policies. There's also a wide variation in the size and the structure and the student population of private institutions that to implement uniform requirements, such as elements of this act, like having an advisory committee, it would impose really restrictive obligations onto some of the smaller institutions. But that being said, there are already appropriate mechanisms through the Degree Authorization Act, the Private Training Act, and the Education Quality Assurance Policy, which requires them to have these policies. And the action plan as well that is accompanying this legislation is going to give government better ability to align their policies and standards with sexual violence and response across all post-secondary institutions, including private institutions.
Member. The definition of member of the institutional community includes contractors and volunteers. There doesn't seem to be a requirement to screen or train them before granting them campus access. Is there thoughts of adding anything like that to the legislation?
Minister.
Thank you, Honourable Chair. So in this circumstance, it's the reason they're included in the definition is to ensure that they're covered by this act. We aren't determining who a contractor is or a volunteer, but that would be done through the screening process of the public institutions. This is just to make sure that if they are coming on in those roles, that they're a part of the application of this act. And that's really important because previously this act, the previous version of this act only applied to students, and we know that when it comes to sexual violence on post-secondary campuses, it's not just limited to students. So whether you're a volunteer, a contractor, employee, we need to make sure that the act applies to you, and that's why they're included in the definition.
Member.
Thank you, Chair. Just gonna, I don't know if I caught it in there or not, but the requirement to screen or train them in advance is that something required by the universities under this act or not?
Minister.
Thank you, Honorable Chair. So with this, with this meaning of it, they are captured in the definition of what an institutional community is, but in terms of determining whether they can be a contractor or a volunteer on institutions, that's something done by the institutions, and they already are expected and will, in their hiring processes, look at, you know, their background and all of that. That's on the institutions to do so. But in terms of this act, it is to ensure that it applies to anyone that is on campus, anyone that's a part of that community is a part of being captured by this act.
Member.
Thank you, Chair. This bill, I'm not sure if it reads, does it actually exclude or include former student, staff, and alumni from the definition of the institutional community, which really would ultimately allow people to dodge responsibility for any of the sexual violence from recent graduates, people that have left the institution.
Minister.
Thank you, Chair. So with this legislation, first, the list of individuals that are listed under member of the institutional community, that's not an exhaustive list. So if it was a past student, if it was a past faculty member, and they were on the post-secondary campus at the institution, could be included in this definition. And in terms of past, if something had happened in the past, there's already sexual violence policies at all these institutions, so there's already a process that those would be captured under. But for example, if something happened in the past and then the disclosure occurred after this act came into place, this act would apply to that.
Member.
Chair. Just on the definition of disclosure, as a non-actionable communication is kind of how I read that. But why is there no mandated, or is there mandated support? I don't see it on the follow-up for disclosures. Which kind of leaves survivors in limbo on that to the whims of whatever has been created at the university. Not that it's actually a whim, but thank you.
Minister.
Thank you, Chair. So with regard to what disclosure is in this situation, if a student comes forward and is sharing with the institution what happened, the disclosure helps them get the supports that they need to move forward. So whether that's, accommodations with writing exams, or if they need supports, that's what the disclosure refers to. If they want to launch an investigation, that's where it would be a formal report would be made to lead to such an investigation. So in this situation, it's just disclosure would, it's not at a whim, it's institutions have protocols in place, and disclosure would ensure that the institutions can move forward to help support the student that has experienced sexual violence.
Recognizing the member from Chilliwack North.
Thank you, Madam Chair. So my question is around the term, the difference between the term sexual misconduct and sexual violence. They're two very different things, and I'm wondering what are the legal ramifications between the two terms?
Minister.
Thank you, Chair. So with the updating of this legislation, one of the reasons was because the word misconduct in itself is, through the work that we've done with partners and seen in general in communities, that it's really inappropriate and outdated as a term that's been used. And by using the term sexual violence, it's more appropriate to what's actually occurring. It describes the act more significantly. It also is a more trauma-informed term that includes a wide spectrum of behaviors from harassment to voyeurism to sexual assault, and it accurately represents the spectrum of behaviors that policies should address and that our intention is and that institutions want to work with us to help address. So that's really the difference, is it's just a more wholly encompassing term of what we're trying to capture here. And overall, there's not necessarily a legal difference in that way, but legal throughout Canadian jurisdictions, including BC, the term sexual violence is what case law and judges have moved towards, so that is reflective of the language we're using.
Member.
Thank you. Thank you, Madam Chair. So obviously, sexual violence is a very, very serious accusation. And so if someone is maliciously or wrongly accused of sexual violence, what are the recourses they have afterwards?
Minister?
Thank you, Chair. So the use of the term sexual violence in this course is to ensure that there's the right processes in place and that it recognizes the seriousness of the crime, as you've noted as well, that sexual violence is very important and serious. And if a victim faces that, it needs to acknowledge that in this language. In terms of any stigma that someone would face from having a case of sexual violence against them, it's important to remember that this process in the post-secondary sector isn't a criminal case or held a public hearing. This is where the victim would come forward, bring forward their facts, an investigation would be done by the institution, and the results of that would all be private. So that stigma factor of using the word sexual violence is different in this circumstance. And it also still allows and recognizes how significant of an impact such an act can have on a victim without having the public impact that would happen if this was a criminal case of about sexual violence.
Shall clause 1 pass? So ordered. On clause 2, recognizing the member from Surrey Panorama.
Yeah, with the sexual violence definition, which is carried over to clause 2, I mean, it seems fairly clear, but if there's, I just want to make sure there's not really any grounds for misreading. But sexual violence, it includes the threats, attempts, and it seems clear, but I just want to clarify, does it include verbal threats, online threats that trigger the same institutional responses?
Oh, maybe Deborah will be here shortly, because she's not talking anymore. Okay. Look at that. Okay, we're just...
Recognizing the minister.
Thank you, Chair, and welcome to the Chair. So to answer your question, yes, if there were acts that were done that would be considered sexual violence that were physical in person, they would also cover any acts of the same nature that were to occur online as well.
Oh, sorry, Chair.
Recognizing the member from Surrey Panorama.
I got a new chair here, and I've already forgotten about you. Thank you. Thank you for being here. Welcome. Sorry. When my friend was asking questions, actually just sort of popped into my mind about the seriousness of this. And again, much like my last question, it seems fairly clear that, you know, these are all serious offenses that are being looked into. I just want to confirm, you know, using some of the terms today that people get offended by do not fall under this legislation. So, say, misgendering, using the wrong pronouns would not be captured under this legislation, then, under this bill, sorry.
Recognizing the minister.
Thank you. So as I said in the previous answer, if the act was to be in the definition of sexual violence, so what's outlined here and what would be in actions in line with what is here in terms of sexual violence, and that was to occur online, then it would be considered sexual violence. It's not a wide scope of things that happen online. It must meet the definition of what sexual violence is first, whether it's in person or virtual.
Recognizing the member.
Thank you, Chair. I'm looking at the seriousness of that, so I'll just try and re-ask the question if I can get a different answer on that. Is the level in there? I mean, these are all, I think these are all criminal, and so we're looking at things like I said, if I was in front of not whether it's virtual or written or anything else, under any aspect of that, would it be, you know, misgendering somebody using the wrong pronouns? Is that captured on this, or, you know, are we only looking at the serious offenses that fall, basically, that are criminal?
Recognizing the minister.
Yes, so just to confirm, the example you're giving would not be captured under this.
Shall clause 2 pass? Aye. So ordered. Shall clause 3 pass? Aye. Recognizing the member.
Thank you, Chair. Sorry, so when we look at Section 3(1)D, just to make sure, we've got a policy that addresses prescribed matters, but under prescribed matters, but the regulations, as far as I'm aware, don't exist at this point. Are we relying on future regulation that we don't know whether it's going to materialize or not on that, or do we have a plan on the regulations? Thank you.
Recognizing the minister.
Thank you, Chair. So that section is just to allow the flexibility that in future, as we've seen with this legislation, that's changed previously as we've gotten to know more. The definitions have changed. We've been able to capture the full situation. We want to make sure we have the flexibility built into this, that as we continue to partner with stakeholders and partner with community partners and post-secondary institutions, that we have the ability to address any future impacts to address sexual violence. So that just gives us the power to do so, to capture that without having to draft new legislation and new acts to capture any new definitions that occur.
Recognizing the member.
Thank you, Chair. I think you've answered one of my other questions there, so that's perfect. Are there any consequences laid out for not meeting any of the requirements set out in Clause 3?
Recognizing the minister.
Thank you, Chair. So when it comes to this policy, there is the expectation that we have that institutions are going to comply. But more than that, I want to highlight that the post-secondary institutions are truly our partners in this work, and they want to comply, and they have been meaningful partners in getting us to this place of putting this legislation forward. And we've actually able to give them more tools to implement that, and we'll talk about that later as we get into first sections, but to give them the authority, but also the clarity of what they're able to do to support students. So we know that institutions are invested in ending sexual violence in post-secondary communities, and that no legislative penalties have been required to date to have them, to ensure their compliance with the sexual violence policies that they currently have. We work collaboratively with post-secondary institutions. We're going to continue to do so and monitor compliance through annual reporting mechanisms, and we expect an existing oversight mechanism. So if an institution is suspected of not complying with the Act or its own policies, community members are able to file a complaint with the BC Ombudsperson, and they're able to investigate and determine whether the established policies need any corrective actions, and to promote accountability through impartial review at that time.
Recognizing the member.
Thank you, Chair. Just going to follow up with that on just a little bit. It was very thorough, but I will ask, are there any penalties for institutions who do fail to meet these requirements?
Recognizing the minister.
Thank you, Chair. So, as I said, this is something that institutions are partners in, and they're invested in doing this work, and they want to ensure that their sexual violence policies are the most up-to-date that they can be. So that's the work that we're doing with them, and to date, there's never been any need to have any legislated penalties for the lack of having these policies implemented. And also, because we know that institutions want to do this work, if they ever ran into any kind of issues where they are having trouble being able to implement this, we'd work with them, as we have done so in years, and we'll continue to do that work to make sure that they're able to implement these policies, because it's a benefit for them, for the students, and for all of us to be able to have the most up-to-date sexual violence policies and protections in place.
Recognizing the member.
Thank you, Chair. Is there a timeline that the minister expects post-secondary institutions to have implemented the requirements by?
Recognizing the minister.
Thank you, Chair. So after this legislation is passed, we have the ability by regulation to determine, prescribe a date on which it'll become in force, and they'd have to, post-secondary institutions would have to implement their policies. And with that, it gives us the flexibility to ensure that they have the capacity to implement them, but also enough time to do so, and that they are, anything without putting an undue burden on them. But I know that with the work that we've done, institutions are, proactively looking to implement these policies. So we look forward to doing that work with them to get it up and running as quickly as possible.
Recognizing the member.
Thank you, Chair. Just a question about the post-secondary institutions and the standardized sexual violence policies that we have. Are they free to develop their own policies, or do we have, are they free to develop their own policies that meet the government's requirements?
Recognizing the minister.
Thank you, Chair. So yes, so as long as the policies meet the framework outlined within this Act, the institutions are free to develop their policies, but must be in line with the framework outlined in the Act.
Recognizing the member.
I guess maybe I can ask what the rationale, Chair, is for the reason for not having a standardized model. Why is the minister choosing this way to go over a standardized model?
Recognizing the minister.
Thank you, Chair. So currently, we do provide guidelines to all the post-secondary, public post-secondary institutions from which they can build out their specific policies. But it's really important that we recognize that each institution has specific needs based on the communities that they're in. And that's why institutions are working with community partners and stakeholders to ensure that their input is going into this as well. So it's basically the framework that the government's providing, and so they're doing even more in addition to what we've provided to ensure that the needs of their specific communities are met.
Recognizing the member.
Okay, yeah, thank you. Just to clarify on that, I think that answer is very good. Just want to make sure there's, the clarity on that is if the goal is to get everybody on the same page with sexual violence policy and the framework to prevent it. Yeah, why are they not following the same standard, or do we fall into that?
Recognizing the minister.
Thank you, Chair. So with the framework, there is a standard. There is a base standard that each post-secondary institution would have. This just allows them the flexibility to have additional aspects to their policies that meet the needs of their specific communities. It wouldn't make sense to mandate institution maybe in the Lower Mainland in an urban center that has different community needs than maybe a rural campus. So it's basically the framework, and so I would say it's an additional tool that they have to strengthen protections against sexual violence on their specific campuses.
Recognizing the member.
Getting down to section 3 there says the institutions are required to have the policy publicly available on a website maintained by or on behalf of the post-secondary institution. Just because of the website portion of that, where would it be captured if these pages end up on a sub-page, a broken link, something like that, where it's not accessible to most people? When does that get captured on a review? Is it their responsibility if it doesn't show up? Again, this is going along the lines of when you were talking about they want to take part, but is there any monitoring as well on that?
Recognizing the minister.
Thank you, Chair. So the review of these policies by our ministry is done on a regular basis. So it's something that if there was to be a broken link, it would be caught by that review. But also if the institution was to catch it, or if someone was trying to access that and saw that, it's something that, they want it fixed just as much as we do. So people have access to that policy that they've worked hard to implement in their institutions.
Shall clause 3 pass? Aye. So ordered. Shall clause 4 pass? Aye. Recognizing the member.
So into clause 4, we get into the implementing and reviewing the policy, and in that, it I think begs the question: is the government going to be providing funding for the smaller institutions who may need to hire additional staff, deal with the objectives that we've got laid out in here?
Recognizing the minister.
Thank you, Chair. So Section 4 really provides the clarity aspect to the sector and the guidance on the objectives of the post-secondary institutions policy and response efforts when it comes to sexual violence. And the intent is really to help ensure greater consistency in the policies for public post-secondary institutions. There's no direct fiscal impacts to post-secondary institutions as a result of these changes that we're making, though post-secondary institutions may require capacity funding to support implementation. Funding is not actually required to implement the changes because these are policies that are in place right now. These are just additional tools and tightening of the accountability and transparency measures, but the post-secondary institutions already have policies in place and structures in place to implement these, so that's really where this would be captured.
Recognizing the member.
Thank you, Chair. I've got several, I guess there's 5 objectives in the in clause 4. They're non-enforceable aspirations that we have in there, but do we have any metrics, accountability mechanisms, accountability mechanisms that would cover what we have in there?
Recognizing the minister.
Thank you, Chair. So when it comes to the accountability mechanisms here, we'll talk about it a little bit further in Section 9 when we look at the annual reporting mechanisms. And we would be getting copies of those reports as well, the annual reports, and able to monitor to ensure that the objectives are being met by the institutions and they're meeting these objectives outlined in Section 4. The fact that these annual reports, which we'll talk about later, are going to be posted on the website and are going to be open for public to look at really increases the accountability and transparency piece as well, so that the community themselves can also hold post-secondary institutions accountable, looking at the report, seeing if they're meeting these objectives and the objectives to respond to and prevent sexual violence in the first place.
Recognizing the member.
Objective E, it requires responding to persons most likely, let me read it off here, responding to the persons and groups who are most likely to be disproportionately impacted by sexual violence. Is there any layout of who those people are that we have that have been identified through this bill?
Recognizing the minister.
Thank you, Chair. So when it comes to determining who the groups are that are disproportionately impacted by sexual violence and the vulnerable communities, it's not something that we can uniformly define. It's something that post-secondary institutions will define for their campus community in consultation with advisory committees. That if their community, so they know their needs. We know generally from facts and data that there are specific groups that are disproportionately affected, like including Indigenous women that are disproportionately affected by sexual violence, and that's why it's so important that in developing this legislation, we've worked with post-secondary institutions, but also our Indigenous partners and community partners to really develop a leading sexual violence policy act that is leading the way across Canada to protect vulnerable populations.
Recognizing the member.
Thank you for that answer. Thank you, Chair. Yeah, actually, that's where I was hoping to lead on that with Indigenous women is clearly laid out, and lots of statistics. It's part of the strategy guide from the ministry, I believe, as well. You do bring up that the Indigenous consultation on this bill. Can you give us just a little bit on what happened with the Indigenous consultations?
Recognizing the minister.
Thank you, Chair. So something I was able to speak to a bit in second reading was the extensive consultation and engagement that we did to get to this point in this legislation. So from 2022 to 2024, we met with a number of groups, and in specific, to answer the question, we met with the First Nations Education Steering Committee, their staff and their board members. We met with Métis Nation BC, and we received written recommendations from them as well, and that was input into our feedback. We met with different First Nations from across the province, Inuit students as well, Indigenous youth interns, and really continue to do that engagement throughout over 2 years of time, including in person and with written recommendations to us, and that's what helped inform us, our policy here.
Shall clause 4 pass? Aye. Shall so ordered. Shall clause 5 pass? Aye. Recognizing the member.
In what circumstance would the minister direct a post-secondary institution review its sexual violence policy if they're already required to do so every 3 years?
Recognizing the minister.
Thank you, Chair. That 1B there is really there to ensure that we have the flexibility to respond should the circumstances arise where we need to do so, and it's outside of that 3-year period.
Recognizing the member.
Following up on that with the reviews and completing the reviews under Section 2 and Clause 5, does the minister have a timeline in mind for when a post-secondary institution must make amendments to their policies based off the reviews?
Recognizing the minister.
Thank you, Chair. So we don't have a set timeline on when those amendments would have to be placed, but we would work closely with the post-secondary institutions to make sure that they were implemented in a timely manner.
Shall Clause 5 pass? Aye. So ordered. Shall Clause 6 pass? Aye. I recognize the member.
Thank you, Chair. As it's covered again here in this one, but we've talked about a little bit earlier, will there be any additional funds available to post-secondary institutions that may require additional help with establishing the committees to advise them on their sexual violence policy? I say that because it's different than just the policy. We're now running under committees.
Recognizing the minister.
Thank you, Chair. So when it comes to the framework of this, this is a lot of the work that post-secondary institutions have already done. As we said, they already have sexual violence policies in place since 2016, and they have worked with us to get to this point of the legislation that we're presenting. So they've done a lot of that groundwork already, but there's no dedicated ongoing funding for this piece, but requirements are designed in a way to be manageable within existing budgets for post-secondary institutions. And we've also considered the timelines and expectations to avoid any kind of undue burden onto post-secondary institutions. That's why we have the flexibility built in to the implementation phase. We're also, as a ministry, providing in-kind support to institutions such as training, resources, toolkits, and other resources to help reduce any kind of development costs to their institutions.
Recognizing the member.
Thank you, Chair. Thank you, Minister, for that answer. It covers another question. Thank you very much. So in subsection 3, can the Minister define what reasonable efforts to ensure the membership of the advisory committee reflects the diversity of persons in British Columbia are?
Recognizing the minister.
Thank you, Chair. So when it comes to reasonable efforts, I think determining whether or not those have been made would really be looking at whether the community support is there and the community sees themselves reflected in the makeup of that advisory committee. But that language to make reasonable efforts also indicates that we understand that it's difficult for, it might not be possible in all circumstances, but institutions will make reasonable attempts to get that diversity, but that might not be possible in all circumstances. So it's really to encourage that that's what's occurring, and that it's reflecting the diversity of our communities, but ultimately it's looking at the community that they're in and if the community sees themselves reflected in the makeup of the advisory committee.
Recognizing the member.
Thank you, Chair. Again, thank you for the answer. So it sounds like there aren't any specific quotas in mind, but is a proven attempt by a post-secondary institution enough for the minister to say that reasonable efforts have been undertaken?
Recognizing the minister.
Thank you, Chair. Yes.
Recognizing the member.
I'm going to back up to 6.2 here. It requires at least one, oops, sorry, I'm looking at the wrong section. One member of the advisory committee must be a student of the post-secondary institution. I just want to make sure it's not something in here that, and I hate to use the word tokenism, but that, we've just got to token one person. Is it a meaningful mandate to do that, or are we limiting what's going on by saying that?
Recognizing the minister.
Thank you, Chair. So having at least one student on the committee, that's something that we heard in our consultations with students, that it was very important that they had representation on this committee as decisions are being made that affect them the most, truly. So having at least, that's just at least one student. You can have more than one student. We'd encourage institutions to look at who's interested and what their needs are, but having at least one student ensures that we meet that need that we really heard from the community, that students need to be represented on this committee.
Recognizing the member.
Thank you, Chair. The bill, just want to follow up again on that, but does it require advisory committee recommendations to be binding or even publicly reported, or are they just advisory in name only?
Recognizing the minister.
Thank you, Chair. So by nature, an advisory committee would give advice to the post-secondary institutions, but it's something that I know post-secondary institutions truly value when it comes to this. And further, when we get further into this bill, in Section 7, when it comes to policy reviews, the institutions are required to consult with the advisory committee. And under Section 9, when they report out, they are required to report out on those consultations. So there is a mechanism there as well for the advisory committee's consultations to be reported publicly for transparency and accountability.
Shall Clause 6 pass? Aye. So ordered. Shall Clause 7 pass? Aye. I'm recognizing the member.
We fall under the regulations again here. Section 7 requires consultation with prescribed persons. Again, the regulations don't exist. So why are we creating legal contingent on undefined future rules?
Recognizing the minister.
Thank you, Chair. So with the definition of prescribed persons, this will be defined through future regulations, and that what it does is allow the flexibility to address evolving needs and ensure meaningful consultation with community partners, Indigenous partners, post-secondary communities, and students. Again, this is to ensure that in future we don't have to start new legislation to meet the needs of the moment, and we're able to adapt our legislation to whatever the needs are as time goes on.
Recognizing the member.
Thank you, Chair. I was just wondering if the minister then can define prescribed persons or prescribed classes of persons.
Recognizing the minister.
Thank you, Chair. So again, with prescribed persons, it's there to ensure that future regulations can capture the flexibility of ensuring that through meaningful consultation with community partners, we could develop those regulations of who those prescribed persons are. If it was a specific group, they would be listed in that already.
Recognizing the member.
Thank you, Minister, for the answer. Thank you, Chair. Institutions must only make reasonable efforts to consult student societies and unions. I think we're allowing an opt-out for consultation with the groups most affected. And I would say, can the minister explain what a reasonable effort to consult is, and what would that be for the section?
Recognizing the minister.
Thank you, Madam Chair. So under 7A, it actually really outlines the larger question of what you're saying of the students of the post-secondary institution, and those are the folks under 7A that we know are must be consulted when it comes to the consultation process. With the reasonable efforts, the folks that are listed under there, they may not have necessarily input on every aspect of the policy or any kind of review. So it gives us the ability to ensure that institutions are making those reasonable efforts, but if those specific groups don't want to participate or don't have anything to add, that they're not obligated to have their hands tied by that provision.
Recognizing the member.
Thank you, Chair. Thank you, Minister. So would the post-secondary institution have to submit some sort of evidence to the minister to prove they made reasonable efforts to consult with the people in subsection B?
Recognizing the minister.
Thank you, Chair. So under Section 9, with the annual reporting that the institutions are required to do, they would have to provide a summary of any consultations that they conducted, and the expectation in there would be that they would outline the consultations they had and the reasonable efforts that they made if in a certain circumstance they didn't consult with a certain group. That is outlined in Section 7.
So shall Clause 7 pass? Aye. So ordered. Shall Clause 8 pass? Aye. Recognizing the member.
Sorry, excuse me, Chair. Thank you, Chair. In what situation would the minister direct a post-secondary institution to conduct a survey for the purposes of assessing the effectiveness of its sexual violence policy, as well as its efforts to prevent, respond, and raise awareness about sexual violence?
Recognizing the minister.
Thank you, Chair. So this provision actually is something that's carried forward from the Sexual Violence Misconduct Policy Act, and it's been used since in 2022 and in 2025. We've conducted 2 surveys that throughout the sector that help to provide feedback across the sector on perceptions of sexual violence, how student safety, and we know that that information is actually critical in ensuring that we are adapting our policies and legislation to meet the need of the moment. These are things that we will continue to conduct surveys. There's not a set schedule, but our action plan does commit us to continuing to do these surveys. We know that they're very helpful for students to know what the overall picture of sexual violence in the sector is, and to continue to develop our legislation to be leading not only in our province but across the country.
Recognizing the member.
Thank you, Chair. So I've got, the next few questions are actually around the transparency of some of this in the next clause as well. But so even when a survey is ordered, institutions submit the results only to the minister, as there's no requirement to publish raw data or institutional responses publicly. And why isn't there the transparency that should be involved with this?
Recognizing the minister.
Thank you, Chair. So when survey results have come into us as the ministry, for example, this year in the 25 results, they were released on our website. You can find them on our ministry website, and they were released within 3 to 6 months, so in a very timely manner from when we release it to ensure that the public has access to those survey results.
Shall Clause 8 pass? Aye. So ordered. Shall Clause 9 pass? Aye. Recognizing the member.
Okay, to go along those lines of the last question in this section, it requires a summary of responses and prevention efforts, but we have no mandate on numerical data. We don't have disclosures, investigations, any outcomes. Is there any thought on that and why we don't have a list for actual data that we're dealing with?
Recognizing the minister.
Thank you, Chair. So for Section 9, this is specific to the annual report that is provided to the governing body. And in this, you can imagine the amount of raw data there is. So they're provided with summaries of the responses, but should they require, something specific or they want to dig into something, they're able to require that of the post-secondary institutions. And also, as this is implemented, if there's anything specific that, comes to government that in addition to A and B that we would want governing bodies to have, we're able to prescribe that through regulation as well.
Recognizing the member.
Thank you, Chair. Yeah, I do worry about the raw data and numbers as they're, to me, are a great reflection on what's going on. I will move on, and I'm going to just say, because I've got the question there, I think you've answered it 2 or 3 times, so if you don't even want to comment on it, I'm going to give you 2 questions at once. It being the prescribed information in Section C, again, 9(2)C. If you don't want to comment on it, that's fine. I'm going to throw the second question at you is, do you have any intention of the ministry hosting the required annual reports for post-secondary institutions, or will the financial burden be on the post-secondary institutions?
Recognizing the minister.
Thank you, Chair. So just on the prescribed information, just reiterate what I said previously, that should any information as we implement this, the government see that there's more information that the governing bodies need to have, we'll be able to prescribe it through that. As for the annual reports, they would be posted by the institutions. It is where it's really needed. It's the institutions. When people are looking for information, they'll be able to find it, on post-secondary institution websites. It's a lot more cohesive for them, and it's part of the reporting requirements.
Shall Clause 9 pass? Aye. So ordered. Shall Clause 10 pass? Aye. Recognizing the member.
There's only one person voting here, but that's okay. Exactly. Yes, everybody's here. But Honorable Chair, I would like to move an amendment to Clause 10, which would be 10.1, which reads as follows. An agreement between a post-secondary institution and any person, including a collective agreement or an agreement settling existing or contemplated litigation, must not contain any term that, directly or indirectly, prohibits the post-secondary institution or any person related to the post-secondary institution from disclosing that a formal allegation has been made that a member of the institutional community committed sexual violence towards another member of the institutional community. And any such term that is included in an agreement is void.
Okay. Thank you, member. We will take a brief recess so we can make copies of the amendment, so everyone has a copy in front of them. So we'll resume momentarily. I call the Committee of the Whole on Bill 18 back to order. We are on Clause 10. The member moved an amendment, which will be discussed after Clause 10.
So we're on Clause 10.
We are on Clause 10, recognizing the member.
Thank you, Chair. We'll be going to something quite the opposite of this just after this, but while supporting victims, is there a risk that we can violate any privacy legislation in place resulting in any punishments being thrown out that would flow from any reports that come from this legislation?
Recognizing the minister.
Thank you, Chair. So this section provides post-secondary institutions with the express legal authority to disclose information to persons who made a formal allegation and that initiated the investigative process. And this is an important piece that we saw was missing from previous legislation, and it allows victims to be able to be a part of this process. That being said, in the process of providing disclosure, post-secondary institutions are still required to comply with the Freedom of Information and Protection of Privacy Act, and this section is in recognition of that. So they would make disclosure, but it would still need to follow everything in FOIPA.
Shall Clause 10 pass? Aye. So ordered. Recognizing the minister.
Thank you, Chair. I move now that the committee rise and report progress, and I ask leave to sit again.
Those in favor?
You've heard the question. All those in favor?
Those opposed?
Those opposed?
Carried.
Carried.
This committee stands adjourned.
This committee stands adjourned.